it would be good to have selected 3 cases, and also practice these skills to make a effective case brief. So, for example, you will have some precious command in understanding the death penalty from the dissenting views in Foreman and Georgia, and also you will address the challenges about a blue book form of citation. So would keep in due style as required for the general legal researcher. And AP style would be alternative in some cases. Well, actually, Foreman versus Georgia, we have some useful point, and also what in great repercussion through the subsequent course in dealing with death penalty issue. Let us take some part from, for example, Justice Douglas concurs and states that it is cruel and unusual to apply the death penalty selective to minorities whose numbers are few, who are outcasts of society, and who are unpopular, but whom society is willing to see suffer, though it will not countenance a general application of same penalty across the board. And because of discriminatory application of statutes authorizing the discretionary imposition of death penalty, such statutes were unconstitutional in their operation. So in this case, you will find a great deal of a churning which comes around the 8th and 14th Amendments of the United States Constitution. Let us take the opinion of Justice Brennan. He stated the 8th Amendment prohibition against cruel and unusual punishment was not limited to torturous punishments or to punishments which are considered cruel and unusual at the time that the 8th Amendment was adopted. That a punishment was cruel and unusual if it did not comport with a human dignity. And since it was denial of human dignity for a state arbitrarily to subject a person to an usually severe punishment, which society indicated that it did not regard as acceptable, and which could not be shown to serve any penal purpose more effectively than a significant less drastic punishment, that was cruel and unusual punishment. So in this case, you will have some citation which leads into deep history. For example, you will have a result to the conquest of Duke William, and the practice attained in history about background information to complement for the court opinion. So interesting and very interdisciplinary in that sense. Of course, we once have some touch about a legal history research in the digitization age, and I have made some remark about importance of history in the constitutionalism of the United States, and actually antedated document and original state, and many exciting journeys through views and points, history, psychology, and in some cases the death penalty case involves a statistical consideration about the minority or the gender, perhaps mental status is one point of consideration about legalization to impose the death penalty. So you will see subsequent case developments about this area of law, and also points to be associated with our research goals. I have suggested 3 cases to appear in your case brief, and Penny and Edmund versus Florida would be one of them, and also in some cases minor has been discussed, whether it is unusual or cruel, or is due process of law. Actually, the constitutional value was applied to weigh the justice of death penalty, and also you will have some statutory materials, for example, anti-terrorism and effective death penalty, and also the first point of reference involving international covenant, ICCPR, also is related with that primary sources. A treaty is one of federal law, as you know, and could be incorporated into your research scope, and complemented to actually elicit any holistic picture about death penalty justice in the United States Constitution. So, and you will articulate the messages in any implications or meanings to perfect your purpose. And also we have some piecemeal deals about death penalty in the federal context, and should be explored through the consistency with the federalism in the United States, and perhaps some explanation may pioneer the direction of audience or kind of issues. And also we return to the Korean sources. Last day I have encountered some exotic experience. So actually, online mode of subsistence is very exciting. I received some email from the CEO of Google stating that I was selected as one of 12 winners for Google Award. The award money is enormous. Actually, I was surprised to find such luck. So I was exalted, but I instantly made some reflection about its truthfulness, philosophy, and authenticity, reliability is critical, along with the kind of right of privacy, a invasion, plagiarism, and protection of business secrets. The kind of surging, emerging issues is very actually provocative, you see, and now the lawyers and legal professors who the concern of new perspective and a new how to instill a standard justice into online context of laws. And in any way, I personally surprised at the first impression, but I become suspicious about this jurisprudence, and I searched for the online websites about the information, whether the name of CEO is correct, and also the branch office is certainly placed at the city designated in the email letter. Paradoxically, I have found some counterforce which provides information about truthfulness of online internet, the kind of events or incident, and the lawyers and computer scientists were prepared to respond with the client's questions. So it requires some small money. So I became trusted to pay the small money about confirmation. So I placed the question and paid $5 about confirmation, whether it is true or not, false, the kind of fraud might well be expectable in this case, just experimental. And I find it surprising that they provide instant answer that I should forbear from providing any information requested by the sender. That is the kind of craft oftentimes and very likely to be so. So that is one question. And in the process, I find that the online research comes as matter. So lawyers or computer scientists would exploit ways and provide a useful assistance to prevent from fraud. That is 5 or 10 minutes research plan, class instruction. How do you find it helpful? Actually, the impact is very foundational. Not only with a general base of people, but also with professionals. In some cases, research is sellable with $5, and in that case, the cost-effective research would perhaps be the experience and the kind of basic sensibility and usual pattern of exposure about the issue. So I have purchased his knowledge. And also we would be concerned of some issue involving authenticity and reliability in the modern electronic society. Now in the screen you will see a second optional protocol to the International Covenant on Civil and Political, aiming at the abolition of death penalty. And this public website has provided in Korean language the kind of background information about your research. And we'll see historical development, and also some classic point of source about philosophy, and also we have statistical information about the group of abolition states and that of maintaining states. So actually Korea also is proactive to have a step of consonance with international movement or progress. So execution is virtually disappeared in the recent decades, and Great Britain has abolished the system of death penalty as a national policy around 1960s. Far earlier to be advanced among the states, and so you will be interested in the Constitution Code of Korea, and you will find some precedents which was disposed involving death penalty. Let us type the keyword in search box. Then we'll have the case law information, and the case law was compiled and made to public access, reference, and consultation, and you will see the whole text of court opinions. So perhaps in volumes, since the Constitution Code has now have decades in history. It was established in 1987, based on the new Constitution reformed in 1987. Actually, the constitutional reform has been initiated to reform the election mode of a presidency. However, it entertained a great momentum to realize a liberal scheme of constitution. So the right of privacy has been incorporated into express provision, and what actually the constitutional adjudication has been one point long envisaged by constitutional scholars. It actually enables the kind of a constitutional culture and a rule of constitution, which is considered a basic element to sustain modern democracy. And the people now have basic rights to contend to safeguard their constitutional rights. Actually, a very detailed system has been founded and as accompanied with provisions of statutory constitutional statute. So actually we have some embedded practice about procedure and substantive rights, and many case laws has been enriched to complement the meaning and direction of command of constitutional provision. Helpful. And you will find in the cases now in your vision of three and the code will enunciate what the kind of principles and also points to be reflected about its sustenance or any outlawing from the ground of a Korean constitution. So you will see some follow-up search at this class to explore in depth about the court opinion. So fairly be spelled out in my expectation to point to many of your considerations. So it would be helpful, and please bear to read the whole text of court opinion, since you will have some a months or 3 weeks research plan perhaps be addressed over the period of this term. So that is hypothetical, and I suggest your deep engagement to be incorporated into your final project. Okay. I have some expectations about your difficulties in the research operation, since it is in high subtleties amenable to the choice and preference of research. Please consider the budget and time constraints, and try to your best efforts to make any productive research operation which will eventually lead to cost-effective work. Okay, thank you for your attention, and we'll see in the third session of this class shortly. Okay.